Yesterday, I was the victim of bad timing. I should have done something on Brennan yesterday, but I took the time partially because I had other commitments that afternoon and partially because I needed to cool down a little bit after seeing what happened. I'll tell you more here in just a second. Hi, Tony DeWitt here. I'm a Missouri appellate attorney, retired, and I bring you a fresh perspective on the law without offering any legal advice. So pull up a chair. This is what we're discussing today.
Your Honor, my brief review of the lab paperwork and looking at the hoodie, it appears that I made a mistake. And so I think what should happen is there should be a curative instruction. There should be a stipulation. The court should instruct the jury that during Mr. Brennan's cross-examination, he asked Dr. Wolf about holes on the sweatshirt or holes on the back of Mr. O'Keefe's sweatshirt. The parties agree the holes were made by a crime lab technician. This was done inadvertently but should not have been asked. The court should strike the questions and the answers. And you should instruct the jury there to completely disregard any questions or answers about the holes in the back of the sweatshirt. And the court should allow the defense to introduce the lab paperwork.
Did you catch that? It appears I made a mistake. It appears. I didn't make a mistake. It just appears that way. You know, if you just hold it up and look at it the right way, it won't be a mistake. It would just be malfeasance. So by now, all of you have seen video of Hank's use of this sweatshirt that had been cut by the criminalist, and he used it in such a way as to suggest that having not seen the actual sweatshirt, well, then this expert must simply be wrong, and clearly there's road rash on the back of it. And of course, what he did was he claimed that, oh, it was a mistake. Well, first, Lally had been at the first trial. He knew that the sweatshirt had been cut by the criminalist. He had an affirmative duty to speak up when he saw Hank going down that road. If he'd gone up to Hank and said, hey, you got that wrong, you need to fix it, then Hank could probably have preserved some indicia of credibility by saying, oh, Your Honor, I'm sorry, I just made a huge mistake, I need to fix it. But instead, he sat there like the cat that ate the canary and waited for the defense to catch on and do something about it. And there was a pretty good chance that he wouldn't have, told the judge what had actually happened if the defense hadn't actually caught him red-handed doing it. So when he says that he's sorry, I think what he's sorry for, in my opinion, what he's sorry for is getting caught and not that he actually did it. Because Hank wants to win. That's all he cares about. He wants to get a conviction. It doesn't matter if that violates Karen Reed's rights. It doesn't matter if it violates the Constitution. It doesn't matter if he has to work on the skeevy side of things to get it done. He just wants a conviction. And that is not the duty of a prosecutor. I've said it on here before, but I'm going to go over a few ethical rules that govern lawyers that absolutely should have been followed here. The first one is this: a lawyer shall not knowingly make a false statement of fact or law to a tribunal, or fail to correct a false statement of material fact or law previously made to the tribunal by the lawyer. Notice that it doesn't say after you get caught doing it. It says you can't do it. Now, either he knew that that was wrong or he didn't, but I'm pretty sure that if you could look at this and tell that they were cuttings, which apparently the defense could, then certainly Brennan should have known. And if he didn't know, why didn't he know? He's the prosecutor. He's the lead prosecutor. He has an absolute duty to know what's going on in the case, to know the evidence, to know the facts, and he blew it. And it's worth noting, as pointed out by Mr. Alessi in his argument, The two pieces of evidence that would have demonstrated this beyond all measure of dispute were omitted from the state's evidence. They were not made exhibits. And so, if the jury had been allowed to hear this and then gone in and tried to do their deliberations and wanted to see what was there, the two pieces of evidence that showed the intact sweatshirt, they wouldn't have been admitted. They would not have been a part of the evidence that the jury could rely on and figure things out. So it really does sound a lot more like prosecutorial misconduct than, oops, I forgot to put a period in there. Left the comma out. Darn, I do that too often. Oh, I didn't put an apostrophe to make it possessive. Things happen. That's a mistake. This is not, it doesn't sound like a mistake to me, I'll put it that way. Having made this false statement of fact, both to the court and to the jury, he had a duty to correct it. And the only correction that was offered by the judge, which said, oh, the criminalist put those holes there. Now, hopefully, the jury is smart enough to figure out that this prosecutor, apparently, he tried to pull a fast one, pull the wool over their eyes. They ought to be upset about it. Whether they will or not is another question. In the comments to these rules that govern the lawyers under the ABA, it says legal argument based on a knowingly false representation of law constitutes dishonesty toward the tribunal. Obviously, the same thing applies to facts. A lawyer is not required to make a disinterested exposition of the law, but must recognize the existence of pertinent legal authorities. Furthermore, as stated in paragraph A2, an advocate has a duty to disclose directly adverse authority in the controlling jurisdiction that has not been disclosed by the opposing party. The underlying concept is that legal argument is a discussion seeking to determine the legal premises properly applicable to the case. So you can't get up and spout a bunch of facts that aren't facts and argue in that regard about them, and that's just wrong on so many levels, but it clearly violates the ethical rules. And while we're on the subject, here is another rule that applies. A lawyer shall not unlawfully obstruct another party's access to evidence or unlawfully alter, destroy, or conceal a document or other material having potential evidentiary value. A lawyer shall not counsel or assist another person to do any such act. Here I'm thinking about the videotape in the Sallyport. B. Falsify evidence, which is sort of what happened the other day. Counsel or assist a witness to testify falsely or offer an inducement to a witness that is prohibited by law. And here's what the prosecutor's duty is according to the ABA. A prosecutor has the responsibility of a minister of justice and not simply that of an advocate. This responsibility carries with it specific obligations to see that the defendant is accorded procedural justice, that guilt is decided upon the basis of sufficient evidence, and that special precautions are taken to prevent and to rectify the conviction of innocent persons. The extent of mandated remedial action is a matter of debate and varies in different jurisdictions, like in Massachusetts, where it's apparently absent. Many jurisdictions have adopted the ABA standards for criminal justice relating to the prosecution function, which are a product of the prolonged and careful deliberation by lawyers experienced in both criminal prosecution and defense. Competent representation of the sovereignty may require a prosecutor to undertake some procedural and remedial measures as a matter of obligation. It's worth pointing out again that Brennan did come clean when confronted and said, oh, I made this mistake. So in some respects, he's satisfied the ethical obligation to correct the mistake, the inadvertent mistake, right? But on another level, you have to look at it from the standpoint of why didn't he know? Why didn't he know what that was? How close of a look has he had at the evidence? He can hold up the actual sweatshirt and point to the holes in the back of it, but he doesn't know the provenance of those holes. Sometimes that happens as a result of a mistake, and I'll give, I have to give Brennan credit in terms at least for coming forward and admitting what happened, But I just have my doubts as to whether or not it was truly inadvertent when you combine it with the fact that those two pieces of evidence from which that could have been discerned were completely omitted from the state's case. That just that has an odor about it that is not a pleasant one. There is a long history in American law of prosecutors who go too far meeting justice of their own. One of those is with a lawyer by the name of Tara Moorhead. Tara Moorhead was a federal prosecutor in Kansas and also a state prosecutor in Kansas. As a Wyandotte County, Kansas prosecutor in the 1990s, Moorhead helped Kansas City, Kansas Police Department Detective Roger Golubsky frame Lamont McIntyre, who subsequently spent 23 years in prison for a double homicide he did not commit. In McIntyre's case, Moorhead presented no physical evidence tying him to the murders and relied solely on the testimony of a witness, Nico Quinn, who later recanted. Nico Quinn stated that Moorhead threatened to jail her and take her children if she didn't lie about what she saw. Moorhead also failed to disclose that she had a past romantic relationship with the judge presiding over the McIntyre case. So, Moorhead and the judge ruling in the McIntyre case were intimate, physically intimate, prior to the case coming before that judge. She had an absolute duty to disclose that to the defense, and the judge had an absolute duty to disclose it to the defense. Neither one measured up. Her conduct in the case came under scrutiny during McIntyre's exoneration in 2017, which revealed, according to the federal court hearing the case, a manifest injustice. There was interference with a fair trial. After moving to the U.S. Attorney's Office in Kansas, Moorhead became involved in other alleged ethical breaches and was removed from criminal cases in 2021. A U.S. Department of Justice investigation criticized her actions after a federal judge in 2017 tossed a defendant's conviction on drug charges. U.S. District Judge Julie Robinson publicly admonished Moorhead, ruling that she had interfered with a defendant's Sixth Amendment right to a fair trial and substantially interfered with a defense witness's decision to testify. Moorhead was the subject of a federal investigation by the Justice Department's Office of Professional Responsibility, though the results of that probe are not specified. In other words, the Department of Justice Office of Professional Responsibility has not released the details of that. Moorhead had agreed to surrender her license as part of an agreement with the Kansas Board for Discipline of Attorneys, which then recommended that the High Court accept her request, allowing them to forego a hearing. In addition, Moorhead had to pay out the costs. It was pretty clear that in several cases she had crossed the line. It wasn't just one case, it was 5 or 6 cases that all went in to this idea of getting her disbarred. In so many of these cases, the rights of the defendants were simply trampled on by this lawyer who was a prosecutor. Now, there are good lawyers who are prosecutors, there are bad lawyers who are prosecutors, just like there are pretty much in any other profession. There are bad butchers and there are good butchers. There are good salespeople and bad salespeople. But prosecutors have an ethical duty that goes beyond simply trying to get a conviction. They have to do justice. That's much different than trying to get a conviction. Doing justice requires you to balance it, to play fairly, to not seek an advantage that is unfair. And in my opinion, that's what Mr. Brennan has done here. But my opinion's not important, and it certainly isn't official. If somebody does file a bar complaint against him and he gets called up in front of the disciplinary committee, then he should have an opportunity to present his defense. It may very well have been inadvertent. And just because there are numerous coincidences stacking up in this case Doesn't mean that he's responsible for all of them. There are a team of prosecutors involved, just the way there are a team of law enforcement officers involved. Mr. Brennan said that it appeared that he made a mistake. Well, I don't think there's any doubt that he made a mistake. It appears that it may have been not a mistake, but actually an attempt to gain an advantage. And if it is, that's an ethical violation. But I don't know the facts, and I do not know what was in his head or what was in his heart when this all came, and this line of argument presented itself. So he might be completely innocent. These coincidences all stack up, and they point only in one direction, and that direction disadvantages Ms. Reed. I am sure that there will at some point be some accounting for all of this, and I hope that that time comes when the jury comes back with their verdict and says not guilty. That's what I have for you today. I hope you found it helpful, interesting, or maybe both. If there's a subject you'd like me to discuss, please feel free to send me an email at the address above. If you like what we do, please feel free to subscribe and come on back to the beach tomorrow. I release videos every weekday, weather and work permitting. If you have the opportunity today, do a kindness for your fellow man. It makes the world a better place, one kind act at a time. And now, YouTube has some suggestions for other videos of mine that you might like.